You know, blended families are very common. With blended families, however, come different estate planning considerations. Usually, a parent wants to ensure that their children will inherit from them at some point in time and not leave their children with nothing. So if you're talking about minor children, likely your will is going to contain a trust for the minors to ensure that their assets go to them, they're available for them, they are protected. Oftentimes, if that's the case, we don't recommend that the trustee be the surviving spouse not being the parent of these children. We recommend that another family member of the decedent, like an aunt or an uncle of the minor kids, be the trustee. Let's talk about a bit older situation. Let's say your kids aren't minors anymore. Let's say you have 2 children from a previous relationship, your new spouse has 2 children from a previous relationship, and everybody gets along fine. You might have what we call an I love you will. What that is a will that says, on my death, everything goes to my spouse, and I trust they'll do whatever they should do with the money once they're gone too. Which means, for example, maybe what I was thinking is, I want all 4 kids to inherit equally. Well, think about this. What is going to happen? You die first, you have 2 kids, your spouse has 2 kids. You give everything to your spouse. What's going to happen in their life? Well, depending on their age, they may well remarry. And if they remarry, maybe they have a new will that says everything goes to my new spouse. See how far distant your kids are getting from inheriting from you? Or let's say your spouse doesn't remarry, but you know what? After you're gone, your kids don't have much of a relationship with that spouse or with their children anymore. Things just don't, stay the same, because things don't stay the same. And that new spouse who has inherited everything from you, they do a new will. And their new will says everything goes to their 2 kids, and your kids get nothing. Now, kids aren't entitled to get anything, but see, that's not the point. The point was, it was your wish that your children receive everything. You and your spouse actually had a will that says everything goes on the death of the second of us equally to these 4 kids. But because you died first and your will gave everything outright to your spouse, there were no protections for your kids. Your spouse can do a new will and everything goes to that spouse's 2 kids. Your kids get nothing. What can you do to make sure that your children are not disinherited? What you can do is put in your will something that says, on my death, everything goes to my spouse in a trust. And anything in that trust, yes, is for the benefit of my spouse, but that surviving spouse can't redirect those assets or change the terms of where those assets are going to go when you're gone. So you can have it set up to say everything goes to my surviving spouse during their lifetime, and on their death, everything that's left in that trust goes to my 2 kids. That way you've ensured that your children will not be disinherited. What's going to work best for you? I suggest that you reach out to your estate planning and elder law attorney and ask them the question, how can I make sure my kids will receive and won't be disinherited?